Hi there. Good afternoon, everybody. My name is Chris Justice, and I'm an employment lawyer with Samfiru Tumarkin. And as always, I'll be here to answer hopefully as many questions as I can within the time permitted. So please do get your questions in. Anything to do with employment law. Maybe there's an issue you've got with your employer, a contract you've got some questions about. Maybe you've just been let go, wondering sort of whether what you've received is fair and reasonable. Again, whatever it is, do get your questions in. I'd like to start actually today by chatting a little bit about a situation that kind of came across my desk the other day. This time it had to do with an independent contractor issue, something that I've come across a lot. Some of you out there might be familiar with. So I had a guy who had been hired on as a so-called independent contractor, or a contractor to some extent, for 5 years. Then they made him a so-called full-time employee. And most recently, in the last 5 years, since he's become this employee, the company was sold to somebody else, and he lost his job as a result of the sale. Now, when he was let go, the company that let him go only offered him 4 months. Now, they were taking the position that even though he had been at the company for almost pretty much a decade, that half of that time was spent as a contractor, and the second half of his tenure with the company was an employee. So they're only going to give him credit in terms of a severance package for the last 5 years that he put in as a full-time employee. So I guess the idea is that he essentially becomes an employee 5 years after he starts, but this doesn't usually happen unless maybe you're in business for yourself and then became an employee. But the law is generally going to say that you're an employee for the entire time. So even if half of the time you're at a company, you viewed yourself or they viewed you as a contractor, maybe something other than an employee, and then the second half as an employee, if the day-to-day sort of inner workings of the relationship throughout the whole time are pretty much the same, and we're just putting a different label on the first 5 years as opposed to the second, that's again where the law is likely to come in and say, yeah, I know you've been labeled this contractor for this many years, but in essence, we think you're an employee. We think you're someone with 10 years of service, not just 5. And so there becomes this dispute or debate over how to classify somebody. So whenever you're in a situation where maybe your employer is saying that you're not an employee, you're a contractor, or you were a contractor, and you don't have the same rights or entitlements as an employee, you don't want to assume that, of course, just off the bat, that's the case, that's true. Even if there's something in a contract that you've signed that says you're a contractor and not an employee, that still doesn't mean that that's what decides or determines the issue. Ultimately, it's the law that's going to be what decides whether you're an employee or not. It's not up to you or your company to sort of clarify or confirm how things are to be classified. And so when we look at, is somebody an employee or not? Are they a contractor versus an employee? One aspect that the courts will look at a lot is the element of control. So how much control, whether it's for the time they say you were a contractor or not, how much control did the company have over you, have over your ability to do the work? Did you get benefits as well? A lot of times employees, of course, are going to be receiving vacation. They're going to get some sort of benefit package. So that's not typically linked with an independent contractor. That's more so linked with an employee-employer relationship. You also want to look at the level of risk or the degree of risk that you're at in performing your job as far as financially taking a hit. So again, a true independent contractor may have the opportunity to profit from the work they do through the services that they perform, but they also may have the possibility of losing money. If you're an independent contractor, maybe you've got subcontractors, maybe you've got a lot of expenses, a lot that you're having to pay yourself. Maybe you're paying your own benefits. So you're basically just taking on a lot more risk. Whereas with the employee relationship, there isn't really much risk in the sense that you're always going to be paid your base wage, or you might have an hourly rate that you get paid regardless as long as you work the hours. You're not going to have to be paying out of pocket necessarily for your own benefits. So again, if you're an employee, that's something that's provided to you. You're not going to be hiring others or subcontracting people. You're not going to really have as many expenses as you would if you were this true independent contractor. So benefits and that kind of stuff come into play, and also the tools that you use. So again, an independent contractor is going to typically supply their own tools. They're going to pay for their own tools. But if you're an employee and you're sort of more in that category of things, then you're going to have maybe your tools provided for you. You're going to have a desk. You're going to have a phone. Your company might be paying your phone bill. If you have tools that you need to perform your job, the company will be providing the tools that it has so that you can do the job. Again, this is all more likely going to be an employee scenario versus someone who's expected to pay for and use all their own tools and have sort of no input necessarily from the company. Another issue or another factor we look at when we think of is somebody an employee or an independent contractor is whether the person works for one company. Is this just the only employer they have that they worked exclusively for, that they were paid exclusively through? Or does the individual, the worker, have maybe 5 or 6 different jobs going on at once? Again, more like an independent contractor, if you're someone who's got maybe 5, 6, 7, 8 ongoing relationships at the same time, versus somebody who only has the one job, the money that they receive is only coming from one source, and that's from the company that's coining them or calling them an independent contractor. So exclusivity is another factor that the courts look at. But in this particular case with this gentleman, so again, he was told he was an independent contractor the first 5 years, and so he only got a severance package for the last 5 that they say he was an employee. When I went through all these factors, it became clear that, while he may have been coined or called something for the first half of his employment relationship, when I kind of went behind the scenes, looked at who's benefiting, who's, providing the tools, is this his main source of income? Are they controlling the way he does his job? They're setting his hours. Maybe they're setting out what they expect him to do. Maybe they're reviewing his performance, kind of subjecting him to criticism or performance reviews. All of these things with this guy checked out, that those were, in fact, what was going on throughout his whole 10 years. So when it came to it, it was clear to me that he was an employee, not just for the last 5 years, but for the full 10. And so the offer that he got from the company, which was only 4 months, for essentially a 10-year employee, is going to be a fraction of what he could get. And I informed him that actually as a 10-year employee, you could be getting triple what you've been offered at 4 months. And so thankfully, in this particular case, we were able to resolve. We got this gentleman a lot more severance, actually closer to 12 months. I think it was 11 months and change. And so, again, just an example of a case where he may have thought, well, yeah, I think I was a contractor for the first half of my tenure with these folks. Ended up not being the case. Again, that it was actually the law that was the one that determined, who is an employee, who isn't. And when you go through all those factors, someone like myself or a lawyer at our firm should be very easily able to tell you how it's going to all shake out at the end. And ultimately, we use that to our leverage, and we got this guy much better severance package than he had initially been offered. But again, just goes to show that if you're in that sort of independent contractor employee scenario and you're wondering, what am I? Am I an employee? Am I not? Do I get the benefits that are often associated with employees or not? Just give us a call. We can at least have a consultation, take you through those main factors that I talked about that are going to kind of give you leverage one way or another. But yeah, I figured I'd bring that up because it is a relatively common thing I come across. And I know a lot of people out there, they assume that they're a contractor or that there's some document saying they're not entitled to benefits that are normally given to employees like severance, vacation, etc. But a lot of times they're wrong. And I think a lot of people are unfortunately leaving quite a bit of money on the table just because they think they're classified as something that they're actually not in the eyes of the law. But thanks for the questions that have come in. I'm just going to answer some of those while they're up here. I've got one from Sophie on YouTube who's saying that they were suddenly put on a 90-day performance improvement plan, even though their reviews have been always positive. And it feels to Sophie like maybe the employer is trying to build a case to terminate them. And the question's asked, what should I do? So first of all, anytime an employer comes to you with criticisms of your performance, especially if you know they're not true and may even have performance reviews to back that up, you want to respond in writing, whether you're given a performance improvement plan or maybe it's just a warning letter. You sort of see them maybe trying to build a case. You want to try to extinguish that case. You want to get rid of the case that they're trying to build. And the way to do that is to put in writing your pushback, essentially your input or your thoughts or your response to the criticisms. So when it comes to criticisms, there could be a situation where it's just completely made up. It's just not true. There's no evidence to it. So of course you want to highlight that, just say, this isn't true. Maybe if you've got some evidence to point to the contrary, you could suggest that. So there's those types of criticisms that are sort of not valid. Then there's other types of criticisms that maybe partially are true. So you want to, again, be mindful to kind of parse out what is true and what isn't true, because you don't want to have them putting something in a document that says you're 100% at fault for this when maybe it's only 50%. So that's another example of a response. Another one might be where they don't include the context around things. So they could say, you're not selling enough of our product in the last month, but then completely choose to ignore the fact that they have been forcing you or requiring you to do other work outside of sales as part of your job. And so you may not have a lot of time left in the day to do the sales part. So sometimes they can omit or ignore some of the context. I think that can be important to say, well, hold up a minute. Here's why the numbers are lower. Here's why the criticism you're sending my way is sort of out of context. So you want to try to flesh things out too and put that in writing. And then there might be the odd thing or two that is true about your performance. And I guess to that extent, you can acknowledge that. But whenever there's a discrepancy or dispute, you want to put your thoughts in writing and you want to push back, because if you don't, then everything's going to be sort of in favor of the company. They're going to have their performance review. It's going to be in writing. It's going to set out all their issues with you. And then there's no response from you to that. So then the only evidence on record, at least in writing, is their view of the matter. So that's why it's important for you to put your response in writing, because then that's going to put evidence in your favor on the record, so that if they do try to rely on it later and maybe months down the road, they say, we put you on this performance improvement plan, things didn't improve, we're letting you go, we're firing you. You or a lawyer on your behalf can point back to your response and say, well, no, wait up a minute. Yeah, you did give me my performance improvement plan, but I responded and I basically told you that 90% of what you put in there is just not true, or it's out of context or whatnot. So then what's left? If you've taken out 90%, there's only 10% of it left, perhaps. It's going to, of course, be a lot harder for them to build a case on that 10%. But that's why it's important when it's true to make sure you do your pushback, so that you don't help them build a case against you, so that if they do let you go, they're only going to be able to let you go without cause. And then, of course, from that will follow you're going to be owed your severance. So by responding and putting these things in writing, it may give them the sense of, well, it's going to be tough to build a case against this individual. They're pushing back. A lot of what they're saying is valid. So I don't know if we have much of a leg to stand on. So that's why you kind of want to, like I say, put that stuff in writing. If they do terminate you, if it's for cause, that could be an issue. Generally when it comes to performance, someone has to be almost going out of their way to perform poorly for there to be a case of cause against them. But if it's without cause, then the company's generally going to be entitled to do that. They just need to make sure that they pay you a proper severance package. But for anyone in a situation like Sophie, I think you want to give us a call as well, because these things can be sort of evolving. You can get multiple warning letters, maybe multiple performance improvement plans. So you want to kind of keep up on top of that, keep on the ball with that, and make sure that you're saying and doing the right things in response, just to give yourself a better case if they do let you go, or just to give yourself more options as far as whether you want to stick around in that environment or not. There might be a possibility you could leave and still get your severance without waiting for them to fire or terminate you. But I appreciate the question, Sophie. Thanks a lot. I've got another one in from Devin on Reddit who's saying they have ADHD and requested small accommodations like some additional time for tasks and written instructions. And human resources keeps delaying the process, asking for more proof. How much medical information am I required to provide? And can these delays be considered a failure to accommodate? So yes, to the last question, if a company delays in failing to accommodate you, especially if it's a relatively minor accommodation, even if it bothers them or inconveniences them, or they don't want to do it, or it costs them a little money, they can't generally just put that on hold and not accommodate the issue, especially, again, where it's a smaller accommodation as opposed to a larger. And you've mentioned you have ADHD. I'm not sure how much you have provided to them as far as any support from your doctor. Getting a note from your family physician or maybe a specialist in the area that just simply says, you have these certain symptoms. You don't even have to necessarily give a diagnosis, but just to sort of lay out what your symptoms are and what accommodation is needed in the workplace for those symptoms, how the symptoms are affecting your ability to do your job. So again, you don't need to get into diagnoses. You don't need to get into medications necessarily. You don't need to get into all this nitty gritty. You just need to provide something, generally in writing to the company that says, here are my limitations. This is the accommodation, or this is how it can be accommodated. So the note from the doctor doesn't have to be extensive. It can be relatively short, but it should have a little bit of that information in there, just so that the company knows how to best accommodate you, and that they've got the, the wording or the statement from the expert, the physician, I guess. If you've already given that and they want more information and they're trying to delve into your medical records and just go after a whole bunch of information that's not relevant, that can be a problem sometimes. And it can be, in a lot of cases, improper and even a violation of privacy and other laws to be demanding certain medical information. So it kind of depends to some extent on what you've given them and what more proof, I guess, they're wanting. But it does on its face look like a scenario where you've provided them with some information. They're not happy with it. They don't want to make the accommodation. They want to kind of hold off or avoid having to do it altogether. And then they're asking for more proof to maybe delay or frustrate you in the process. So if any of that is true, that's when the company can get into some hot water as far as, failing to accommodate, human rights violations, and other issues within the workplace. And that might actually open a can of worms for them, for you to have even more options to go after them if you're not any longer comfortable sort of working in that environment. But yes, again, to answer your question, delays can be considered a failure to accommodate, especially if they're not connected to any rationality or they're not of any substance, and it's just a delay tactic on the part of the company. I've got another question in from Teeny, who's asking if someone gets severance if you've worked less than 5 years, and if you've worked almost 4 years, how much severance to expect. So the answer to the first question is yes. You can get severance if you've worked for less than 5 years. You can get severance if you've worked less than 1 year. In fact, there was just a case that came out a few days ago where there was an individual who worked for a company for 3 months, and they received 3 months of severance. So a quarter of a year, and the person still got 3 months. So that's just generally to say that even if you've been there for a relatively short period of time, there are a lot of cases where people with even 1 year of service have gotten 2, 3, 4, 5, 6 months. Teeny, at 4 years or almost 4 years, you could get 3, 4, 5, 6, 7, 8 months. There's a bit of a range when it comes to these things because it depends on a number of different factors. So, for example, have you signed a contract that limits your severance? So if you get let go after 4 years and you have a contract you've signed that limits your severance, you may only get 4 weeks, a week for every year of service. But if you don't have a contract like that in place, or there's not a section in there that's a really well-worded termination clause, then someone with 4 years, like I say, could get 4, 5, 6, 7, 8 months. If you don't have a contract to worry about, generally the only other thing that's going to limit your severance potential is if you get a job afterwards and when that happens. So if you're working for a company for 4 years, but you only go unemployed for 2 months and then you find another job that pays the same, then your severance is likely going to be limited to just the 2 months. But if you've been at a company for 4 years, you're in your 60s, you've been let go, you're making good money, you have a senior role within the company, and it takes you 8 months to find work, you could get 6, 7, 8 months of severance potentially. So again, just goes to show that you don't want to undersell yourself in terms of what the value of your severance might be. You also don't want to assume you're entitled to anything necessarily, depending on whether you've signed something or not. So you want to have your contract reviewed. But in general, in my experience, for the most part, people are always given much, much less severance than they're owed, or at least much less severance than is within the range of what's possible for that person. So I would see a lot of cases where someone's got 4 years in and the offer would be maybe 2 months. And yet, later on we settle the case, they get 6 months or 5 months. So again, don't assume, get some advice before signing off on anything. And do know that even if you've been there for less than a year, your severance entitlements could still be relatively significant. I've got another question in from Vincent, who's saying that their employer reduced their hours from full-time to part-time due to quote unquote budget issues. But they've since hired another full-time employee. They say it's temporary, but take-home pay has dropped by 40%. At what point does this count as a constructive dismissal, and can I refuse the new arrangement? So sometimes there may be legitimate business reasons for lowering someone's pay, in the sense that they're not lowering it in bad faith. They might be doing very poorly as a business and have to cut costs somewhere. So in that sense, there can be some legitimacy or truth to why they're doing what they're doing. But the question of why doesn't really matter if the significance is great in terms of the drop in pay. So it could be completely valid that maybe you've just gone through the pandemic, your business is suffering, you need to cut costs, and you go to an employee and you say, we're lowering your wages by 20%, not even 40, just 20. And it's going to take effect, for the remaining future. There's no necessary end date to this drop. Even at 20% of a pay hit, that's going to generally trigger a constructive dismissal. Even 15% would trigger a constructive dismissal. So that's generally at least what you need to prove, around the 15% mark, I would say, of a drop in terms of your wages. As long as you can prove that, even if it is for business reasons or it's valid, assuming you don't agree to the drop and they just insist on cutting your pay, that's going to be considered a constructive dismissal. So certainly at 40%, that would be a constructive dismissal. That's when there's been a significant change to the terms of your employment. And once there's been a constructive dismissal, you have an option. You can either accept the new terms, which you can't go back necessarily after the fact, or you can sort of draw a line in the sand to say, this is a constructive dismissal. I'm not agreeable to this. This is a significant change to the terms of my employment. And then if the employer still wants to insist and say it is what it is, then at that point, you've done all you can. You've stated your piece. You've kind of drawn that line in the sand, and you may be in a position where you've been constructively dismissed. And now you can almost exit the situation, leave the place as though you were let go, right? Because they breached the terms of your employment, and go after the company for the most severance you can get. But also in a case like this, you want to give us a call. You want to get some legal advice just before writing to your employer and declaring there's been a constructive dismissal. You don't want to kind of get too deep into it without getting that advice, so that you're not saying anything that could be jeopardizing a potential case or your ability to leave and maybe go after them for the constructive dismissal. I've got another question in from Aileen, who's saying that their sister just got let go from her job. They're pressuring her to sign the agreement. They're offering her an extra 3 weeks to do so. She's stressed and doesn't know if she's going to lose out if she doesn't sign. What should she do? So again, I always caution people, don't sign. It's not like if you miss their deadline that your rights are going to go out the window. You have 2 years from the day that you're let go to potentially sue a company and go after them for more severance. And you just don't want to assume that because they're offering an extra few weeks that that's a deal she should just take and run with. Because again, a lot of times, they may be offering you an extra few weeks, but then you contact a lawyer and the lawyer says they should be offering you an extra few months. Forget weeks, it should be months, maybe 4, 5, 6 months. I don't know. So yes, they do pressure you to sign things, but you don't want to sign it at least without getting advice. And if you need more time, I always suggest to people, just let the employer know, I just need a bit more time to review and consider my options. Maybe get some advice on this. Can I have an extension? A lot of times I'll ask for a week or 2 of an extension. And 9 times out of 10, if not more, the employer is going to say, yeah, take the time, get it reviewed, because they don't also want you to be pressured or under duress when you sign something. Then it may not be worth the paper it's written on. But at the end of the day, I would still, even if they did say we're going to take the offer away unless you sign it, assuming you've been let go without cause and they generally owe you severance anyways, I still think it's better to get legal advice before signing it, because as I say, you could be leaving tens of thousands of dollars on the table. And then in hindsight, you're thinking, damn, I shouldn't have signed it. I should have got some advice. I was just really wanting the money. So it kind of depends a little bit on the scenario. I definitely tell you to have her give us a call so we can at least kind of touch base with her and sort of assess the situation, get a lay of the land. But yeah, I'm always cautious about people signing things when they're under pressure like this, knowing that the vast majority of cases I see, people are getting way less than what they should be getting, even with the extra offer if they sign the paperwork. I'll do one more question just before I go. So I've got one from Kareen, who's saying, if your employer is giving you an annual bonus for the last few years, can they decide to stop this suddenly? Is this allowed? And generally, no. It goes back to the constructive dismissal argument, because if you're making, say, $50K a year and you've got a $10,000 bonus, that's going to be, maybe 15 to 20% of your overall wages. So to stop the bonus, and a lot of times is a reduction in your wages, especially if you've been given it the last few years, like clockwork. There are some cases where you may have signed a bonus plan that allows them to do this. So you'd want to kind of look at what the plan or the policy says. Again, get some legal advice as well. But for the most part, in general, I find that when this happens, it's a constructive dismissal. Again, you want to be timely about it to sort of voice your disagreement with it if that's what you disagree with. Because if you're silent on it and you just let it go for a number of months or years, then you're never going to generally be able to go back and insist that the bonus made up a substantial part of your job. But it also comes back to how big of an amount the bonus played in as well. But that'll do it for my time today, everyone. Thanks again for joining me. We've got other Q&As going on all the time. So for those I didn't get around to answering questions, definitely tune in next time. You see down below there, Angus, this Thursday's got a session going on. So tune in then, and I'm sure he'll be able to answer all your questions. But again, that'll do it for me today. Thank you so much, everyone, for your time, your questions, and have a great rest of your Monday. Bye for now.